Attorney Vinci is an associate with Montgomery, McCracken Walker here in the Philadelphia area. She has gotten her BA from Muhlenberg, I think it's university, and then went on to get her JD from Temple University. She works in their litigation and intellectual property department, focusing on intellectual property, higher education, and commercial litigation issues. She's also practiced in front of the Trademark Trial and Appeal Board. She also represented clients in front of bankruptcy court. And part of her going to law school, she was an intern for a district court justice in the Eastern District of Pennsylvania. So we, again, thank you so much for being willing to join us tonight. And hopefully this will be a conversation that continues, because I'm sure we're not going to learn everything we need to know in one sitting. But without further ado, Attorney Brianna Vinci.
Well, it's really nice to meet all of you and to hear about what you do. I was excited to be able to present to all of you tonight and get to meet some new people. So I put together a presentation that is fairly overview, you know, like view from 700 feet or whatever, however they say it, on mostly patents and trademarks, but it covers all intellectual property. Our firm is a full service firm, litigation, commercial business, and intellectual property. And our group for intellectual property has grown over the last few years, and we're able to handle trademark and patent prosecution for clients, as well as litigation on both sides of that. And I'll touch on copyright as well, because I think that's something that you all might be interested in, and that I think pertains a little bit to your work. So I'm going to start screen sharing. And if anyone has questions throughout, please interrupt me. I will not be upset, and I'm happy to talk and make this more of a conversation instead of me just talking at you. But this is an overview of trademark and patent law. And I'm going to walk you through what the types of intellectual property protection are. And then we'll focus a bit on what trademarks are. And I apologize if you can hear the car engine that is outside of my window right now. But what is a trademark, what you can trademark, and just the general process of obtaining trademarks. And then moving into patent law, I know this says the constitutional foundation and a brief history. It's definitely not a history lesson. There's a few little interesting things that we can talk about, but then we'll get into what a patent is, how it works, and how you obtain one. So there's four main areas of IP protection. Trademark, which is the main area of my practice. Trademarks are source identifiers of goods or services. You probably see trademarks every single day. They're essentially brands. Your brand is your trademark. And copyright is what I would call creative expression. It's anything, you know, that you write down and are putting into a fixed format. Things like books, movies, coding is copyright protectable, any kind of creative expression. Trade secrets are confidential information, things that companies want to protect. And patents are in your inventions and discoveries that are protectable. So a trademark has a couple different functions, and it depends on what way you look at it. If you are the person who is providing a service or a product to somebody, you can use trademarks to, you know, identify yourself in connection with those goods or services. They serve as a source identifier, and they also are a creator of goodwill. And really what that means is that it creates an association with your brand. And over time, you know, people get to know your brand based on your trademarks, and they learn to associate them positively. And for the consumer, trademarks are really helpful because they allow you to associate a product or service with a provider. You know that a particular product is associated with a particular brand, and you know you like that brand. And for a lot of people, it's an assurance of quality. Like when you see Coke, you know that you're getting a a good soda, a good cola, so that's helpful on both ends for consumers and also for the person who's providing the goods or services. And you can obtain trademark rights in a couple different ways. What really matters within the United States is that you're using the trademark. So if you have a name for your business, a logo that's associated with your business, a slogan, anything along those lines, and you're using it, you technically have what are known as common law trademark rights. They just exist, they come about. And when you have common law trademark rights, you can add the TM that you might see in like subscript next to a name or next to a design. They don't give you as much protection though as a federal registration. So it's a law called the Lanham Act. It allows you to protect trademarks under federal law. And if you go through the registration process, you're allowed to use the little R within a circle instead of the TM after you receive registration, and you get other important rights. It's just easier for you to protect yourself against infringement if you have a federal registration. It lets you protect your mark across the nation, and it gives you a presumption that your mark is valid. And like I said a little bit before, you can trademark almost anything that identifies the source of the service you're providing or the goods you're providing, whether that's a name, a logo, a slogan. You can the packaging or design of something. Colors are trademarkable, which I always find really interesting. The John Deere green, that color that they associate with the brand is a trademark. Trade dress, which is the best example of this, I think, is the Coke bottles, like the traditional glass Coke bottle, the shape of that, and kind of just the shape of it is what you would call a trade dress, and it's a design of sorts that's associated with the brand. And you can even trademark sounds and scents. I can't say I have a lot of experience in that area, but it's something that you can trademark. And trademarks kind of exist on a spectrum, and what can be trademark exists on a spectrum, and it goes from weak to strong, and it goes from least distinctive to most distinctive, pretty much. So something that's not ever trademarkable is a generic term. So that is something that was once a trademark and it has kind of lost its meaning. It's something like Band-Aid, for bandages, everyone just calls them Band-Aids, and it loses the effect of associating the word Band-Aid with one particular brand. Apparently Escalator was once a brand name, and I did not know that until we put this presentation together. Descriptive trademarks are also a little bit more difficult to obtain registration for. That's something that basically it describes the services or the goods that you're providing. So the example we have here is Computerland for computer stores. It basically just tells the consumer exactly what it is that you're offering. And it's difficult to get registration there because the idea is, you can't have the exclusive right to use the description of what you're doing. It would kind of preclude other people from doing the business as well. And that would be unacceptable. It would be a monopoly, essentially. Suggestive terms, kind of fit somewhere in the middle. They're a little bit descriptive, but they do a little bit more. And the example we use is Greyhound for the buses. And a suggestive term is one that actually has acquired a level of distinctiveness to it. It's been in use for a little while. People are starting to associate the name with the brand, and that is what makes it trademarkable. And the best things to trademark are arbitrary or fanciful terms. An arbitrary term is a real word, but it has absolutely nothing to do with the product or the service, like Apple. It has nothing to do with phones or computers, but it is a real word. And fanciful terms are a little bit different. They are completely made up words, and they are the strongest trademarks, things like Kodak and Exxon, because they're unique and they are really strong source identifiers when they actually are put into practice. This is probably what I think a lot of you might be most interested in, is learning how you protect a trademark. And this trademark prosecution, I always think the word prosecution is interesting because you end up thinking about the criminal justice system a little bit. But trademark prosecution is the process of presenting a trademark to the patent and trademark office, and going through the process of getting a registration. So you kind of start out the process by figuring out what your trademark is. So you'll select your marks, you'll figure out what it is that you want to trademark, whether it's a name or a logo or a design, and you'll present that to an attorney. Most of the time, I would recommend that you go through an attorney, because attorneys have the capability of running clearance and conflict checks. So when I run a clearance check for a client, what I'll usually do is they have a database of every registered trademark, and you can run searches to see if there's anything similar that might cause problems later down the line or lead to a possible rejection. And your attorney can also help you choose the right class to put your trademark into. So the trademark office has different classes that are set out. There's a set number of them. There are limited categories for goods and for services, and you kind of have to figure out which of those categories is best for what you are offering. And after you do that, the application process begins. And the actual process of making an application after that first kind of segment is done is fairly simple. It's fairly inexpensive, the actual application, getting it in and filed. What gets a little bit more involved, and the best time I think to have a lawyer involved with this kind of thing, is after your application is submitted, it gets reviewed by an examiner, and they might, and they probably will, issue what's called an office action. And an office action is a limited rejection of your trademark, and they'll lay out the reasons why, and they'll tell you what you can do, basically what you can do to fix it, and if they think it's fixable. And responding to that sometimes involves a little bit of a legal argument, and I think it's helpful to have a lawyer involved at that stage. And other times they'll just want you to amend what you're describing, or give a stronger description of your goods and services. And at that point, you file a response. If necessary, you might have appeals involved. And after all of that, if your trademark is accepted, it's published. And what publication means is that there's a register of trademark applications that the USPTO, US Patent and Trademark Office, has. And it allows other people to look at those and determine whether they want to file what's called an opposition. That's that last stage in this center right here. A third-party opposition is kind of like a little mini litigation in which someone challenges your right to have a trademark because they think it is detrimental to their right. For example, I know that Ben & Jerry's, the company, they often file oppositions to protect their trademarks. I had a client who was interested in a mark for half-baked, and I advised against it because Ben & Jerry's has a trademark for that ice cream name, and I had concerns that Ben & Jerry's would oppose our trademark, saying that it was either too confusing or it might cause damage to the goodwill or dilute, as we say, Ben & Jerry's mark. After that stage, if you don't have an opposition, or if you win your opposition, you typically get a registration within 1 to 2 months after publication of your trademark. And after that, you just have some minimal maintenance, is what we call it. You have to file an affidavit of year 5 and year 6 at some point in between those 2 years after you get your registration that just says, I am using this, because the key to having a trademark in the US is use. And you can renew your trademark for as long as you're using it. And you just do that every 10 years. That's another reason that I think it's helpful to have an attorney involved. A lot of attorneys, excuse me, have docketing systems that keep track of clients' marks and any maintenance that needs to happen, so that it's pretty much something that you can put in the back of your mind and not think about. Okay, and then we are going to move to patents. If anyone does anyone have any initial questions about trademarks? I can stop for a little bit and talk about that if you guys are interested. All right, hearing none, I will move to patent. Patents arise actually out of the US Constitution, which allows Congress to secure limited rights to people to their discoveries. Pretty much, it's Article 1, Section 8 of the Constitution, which is interesting but not particularly important for us here. And here's the history that I was talking about. It's the Patent Act was first put into place in 1790. And at that time, we established the US Patent Office, and it was headed by Thomas Jefferson, which is just an interesting historical fact. And the very first patent ever was issued in 1790 and was signed by George Washington, which is kind of cool. And patenting is a extensive process, so it's good to ask why you might want to do it. There's a whole bunch of different reasons. What we'd call offensively is either limiting or preventing competition in your area, keeping people from copying the technology that you've developed, and gives you a right to exclude people for a limited period of time. So there's an economic benefit. It can make you the only person in the marketplace for a little bit of time. And it gives you the right to say, my patent is pending or patented on your product, whatever you're putting out there, which gives a sense of legitimacy in the marketplace. And defensively, you can get patents to negotiate kind of what we would call a cross license with another company or another inventor who's working in the same area. And you can use it to negotiate different types of disputes. And then commercially, there's financial advantages to having patents. You can get licenses. You can give licenses to use your patent and charge for that. And you can also use patents to kind of market yourself. And if you are a person or are involved in a company, patents are really helpful because it helps to encourage developments and research within your entity. And it also is good for employee morale because a lot of times companies, especially larger companies, will give like bonuses to employees and really encourage them to patent and to develop things that go on to become patents. And all a patent really is a property, right? It gives you a right to exclude other people from making or using or selling or offering to sell in the United States or importing into the US, whatever it is that you're claiming in your patent. And that exists as a monopoly for just a period of time, and it exists only within the United States. At least, if you get a patent within the US, it is territorial, so it only excludes people from doing those things within the US. But other countries have patent procedure. So if you were to have interest in exploring that, a lot of attorneys, like I have agents that I deal with outside of the US when I want to help a client out with either patent or even trademark work outside the US. And you get a nice little document when the Patent and Trademark Office gives you your patent. There's different types of patents. The most common is what's known as a utility patent. So a utility patent is a product, process, or machine, those kind of inventions. A design patent actually just claims what's called an ornamental design. It's truly just a design. It has no like functional purpose. It could be like the design on the handle to this pen. It doesn't actually serve much of a purpose. And it looks different from the handle of this pen, and you can claim the right to your specific design. And patent terms depend on whether it's a utility or design patent. It's 20 years for utility and 15 for design. And like trademarks, there are kind of maintenance fees that pop up with utility patents, but that's not really something very exciting that we need to get into right now. Oh, and there's also plant patents, which I think is kind of cool. Plants and like different genetic modifications of plants can be patented, and they're kind of their own separate category. So for Utility and design patents, we kind of talked about this on the last slide, but for utility patents, you can patent a process, which includes software or business method. You can patent a machine, an article of manufacture, the composition of matter, or any improvement to those things. And design patents are a little more limited. You can only patent an ornamental design. Ooh. Oh no. Sorry, I struggle with technology very much. The subject matter of a patent is pretty much anything that you invent, but not an abstract idea, a law of nature, or something that occurs naturally within the world. And this is a little overview of what a patent looks like. Within the actual document of a patent, it starts out with bibliographic information. It tells you who invented this, when did they invent it, is the patent licensed to a company or to another person, like who owns the patent right now. It'll tell you the title of the invention. There's an abstract, which is just a short description of what is going on within the body of that patent. There's drawings that actually show you the design or whatever it is that is being claimed. There's a brief background and summary of what's invented. There's a description of what the drawings are, and then there's a more detailed description of what it is that is being claimed and how it relates to those drawings. And then the actual claims of the patent line up. They're numbered, and they just go through exactly what it is that's being claimed and what the scope of the protection of that patent is. So if you're going to read a patent, you have the first and most important thing to look at is the cover page, which holds the title. It'll give you a brief description of the invention. The inventor is the person who's going to choose that description. It'll also show you a patent number, which identifies the patent, and a serial number, which gives you access to pretty much the entire patent application. That's all signed by the Patent and Trademark Office. On the cover page of a patent, you'll also see filing dates, a priority date, which is the earliest possible filing date. It's the starting time for a patent term. And it'll give you the issue date for the patent when the US Patent and Trademark Office actually issued the patent. You'll see the inventors, you'll see the assignee. That's the actual owner of a patent. That can be a person or it can be a company, an entity. There's technology fields. It just kind of runs through the categorization of the patent. It'll show you some of the references that are cited. When you present a patent to the United States Patent and Trademark Office, you give them a list of what's called prior art. It's everything that you find relevant to your invention that came before it. And the Patent and Trademark Office might do its own prior art searching. So everything that is considered to decide if the patent that's presented is new and worth patenting. And then the abstract is kind of like a tweet about what the invention is. It's 150 words or less overview of the invention. And this is what we were just talking about. This is the cover page of a utility patent. Up at the top, it says United States patent. This Polofsky is the inventor. The patent number and the date of issuance of the patent are right up here at the top. Right here at number 54 is the title of the patent. At 75, you'll see the inventor. And 73, you'll see the assignee, and here it's a company. And if you go a bit further down, you can see the filing dates. This prior publication data is relevant to priority. These are the classes for the patent. And then to the right, you can see where the references are cited. And then below that, the abstract, which briefly, quickly, in a snapshot type of way, describes what the invention is. These are patent figures or drawings that show you what the invention is. The numbers associated with them correlate with paragraphs. This is just this is a portion of the patent. It shows the title, and then the background of the invention, and a brief summary of the invention. And in case you ever are in a situation where you're reading a patent, you'll see this number 1 and 2 appear at the top. Those are called column numbers. And then there are line numbers. So this is line 5. And when you refer to portions of a patent, you go by column and line number. After you flip through, you'll find a brief description of what the drawings are, and then the detailed description of the invention, which refers back to the numbers on the drawings that we had talked about before. They're here in bold throughout. And then finally, at the end of the patent, you get to, you'll find it in column 6 right here at the bottom. It says what is claimed is, and there's numbered paragraphs there. That is actually the scope of the patent and what is being claimed within it. That's, I think, the most important part of a patent. When I am looking at a patent for the first time, that's the first place I go, is to the back to see what exactly is being claimed. And then a design patent, it looks very similar at the beginning, but design patents only have one claim, and the claim is right here on the front page, since it's just an ornamental design. And then the big focus on a design patent is the drawings. And this is for the screen of an iPhone. They have a design patent for the way that the screen looks. So to get a patent, whatever you're presenting and whatever your invention is needs to be something that's useful. It has to solve a problem that exists. It has to be novel. It can't have been invented before. It can't be obvious, which means that in light of other things that exist, other previous inventions or products, you can't think to say, oh, well, I have this product and I have this patent, and if I put these two ideas together, I would come up with whatever is being claimed in this patent. That's obvious, and that's not patentable. It has to have a fully enabled disclosure, and what that means, there's that acronym FOCITA below that, but your disclosure within your patent actually has to allow a person having ordinary skill in the art, the FOCITA, to put together the invention based on the description within your patent. And who the FOCITA is depends on the area of the patent. So when I work with a medical device manufacturer on their patents, the FOCITA is usually someone who works on designing medical devices. And to get a patent, it also has to be the original work of the inventors. You have to be the sole and true correct inventor of something. You can have more than one inventor, and as long as everybody actually invented something within the patent. And this, we're moving a little bit further out from patents and talking more generally about what the United States Patent and Trademark Office is, the USPTO. So they are the entity that examines patent and trademark applications. They kind of oversee all policy within the United States and how the US is going to handle intellectual property. And they do things like examine applications, they grant patents, they publish all the information about a patent. They keep records of every single assignment of a patent. So if I invented something and I assigned it to my work, to my law firm, it would be recorded with the USPTO. They keep searching files for all US and foreign patents, which is important for determining if something is novel. And they are DC based or Alexandria, Virginia based. And the people who work there are either patent or trademark examiners. In the patent space, they have to be a scientist or an engineer, and they go through the applications. I don't envy them. That does not seem like a very fun job to me. And they kind of figure out whether something is novel and warrants patenting. Within the patent prosecution process, we talked when we were going through trademarks about, where I think an attorney is most important. And it's really important to have a lawyer involved if you are attempting to prosecute a patent. The lawyer will help you do things like obtain invention disclosures. That is typically something that happens when you work for a company. They'll have you fill out if you're an engineer at a company, they might have you fill out something every single time you feel that you have invented something patentable. It records the date that you did that, because that might matter, the date that you conceived of something. And lawyers can help you and help your company figure out the best way to record inventions that are happening and determine if they're patentable and interesting. And lawyers can conduct patentability searches in a similar way that we would to trademarks. And we can put together reports that say whether or not something is patentable and whether it's clear to move forward. And lawyers can help drafting provisional applications and non-provisional patent applications. Those are just kind of two different stages of that process. And lawyers are really helpful in prosecuting applications before the USPTO. So similarly to a trademark application, there's often office actions and different kind of edits that the USPTO will want to see along the way. They might also want to interview you and learn more about your invention and why it's distinct from something that already exists in the world, for example. And it's helpful to have a lawyer there for those things and to have an attorney on board, because it is kind of law heavy at that point. The patent prosecution procedure, I'm just going to go over really briefly, but we pretty much start with an invention. It's really important to record when you're inventing things. It's called diligent documentation. It's important. If you're at a company, it's good to have a notebook, a lab notebook, and it's important to kind of just keep track of what you're doing. So you can keep track of the date on which you did it and have a good record of invention. And then you go through the application process, and it takes a lot longer with patents. I think it's largely because they're so technical most of the time, and because the USPTO is also very overworked. And then eventually you will get a patent issued if it's something that warrants a patent. And at that point you have a 20-year term if it's a utility patent, 15 for designs, and just minimal maintenance that has to be done. There have been some new developments in patent law. I'm not going to spend a lot of time on them right now because I don't think it's particularly exciting for you guys. But the America Invents Act was effective in March 2013, and it kind of just brought the US up to speed and aligned our patent policy with the rest of the world, more or less. And the big things in patent, like I said, it's really important to document inventions when they're being developed, how they're being developed. It's a good idea to not publish information early. So if you want something to be patented, there's rules on when you're allowed to file and how long after kind of disclosing something publicly before you can actually seek patent protection. And a lawyer, if you have an invention that you're interested in or that you think might be patentable, it's good to talk to a lawyer and figure out what they think before you decide to publish something. And if you know of any relevant prior art, anything that's like came before your invention, but is related to it, you have an obligation to disclose that to the USPTO. And there are ways to distinguish your inventions, and it's really helpful to have a lawyer for that part of the process. So that's the end of that presentation. This is our little IP team. I'm going to close this and then address two questions that I got ahead of time before I open it up, if that makes sense.
Sure.
Okay. So one question that I had was how you can protect an app in terms of intellectual property. And there's a few different ways to do that. So, but the most important, I think, are trademark and copyright. So you might want to protect the name of your app, the logo, if you have a slogan, if you use particular colors. Those are all things that are trademarkable, and they all fall under trademark law. And so if you have a unique name that you want to associate with the app that you're developing, then I would recommend trademark as a means of protection. You can also, again, trademark the logo, any slogans, things like that that you want to use in connection with the brand that you're building around that app. And copyright is also something you might want to consider for an app, because you can copyright source codes. And so for computer software and for apps, coding, whatever the coding is behind that is actually, it's copyrightable, it's copyright protectable. And since it's an original work, it fits within the scope of copyright, which I'm going to talk about in a second. And patent is used least frequently, I think, with respect to apps, because it's really hard to have something in an app that's truly novel. I don't think it can't be done, but I think it's least common. I think copyright and trademark are the best way to do that. And the other question that was presented to me ahead of time was about what the limitations of copyright are. And I'm sorry to not have slides on this, but copyright essentially, like I said in the other presentation, it extends to any kind of original work of either intellectual or artistic expression. So it's basically things like books, photos, music, artwork, graphic design, software programs, even like a business plan or a chart that you put together within the context of your job could be copyrightable. And copyright is a little different from patent and trademark, and it is not as heavy as a part of the presentation that my firm typically does, because copyright actually arises automatically as soon as you create something. And actually, it's called fixation. As soon as you fix it to a medium, that's tangible. So if you put it on paper, if you put it on film, if you put it onto a computer memory, at that point, it essentially is something to which copyright protection attaches. It doesn't even have to be published. It just has to be created and actually fixed in some kind of medium, like print or otherwise. It doesn't matter.
Attorney Vinci, can we just stick with that for a second?
Yeah.
Can you then use that logo of copyright at that point? Is that something, who bestows the copyright logo? Is that something you can bestow on your document yourself?
Yes. Yeah. It's different than like using the R for a trademark, in that you have to have the registration to do that. Copyright, if you have created something unique and you have actually kind of put it into printed form, you can attach the copyright symbol to it.
So just as an example, with everything I publish, it's copyrighted. It's always at the bottom of every document is the copyright. And I just want to, while the attorney is here, I just wanted to show you something as well. This is the trademark for that term that I use for my training. That's the slogan, is attaining your life's best through knowledge. And then this is, if I can stop that, the second patent. I had it open, sorry.
Now, while you're doing that, can I ask you, Brianna, so when you say something is copyrighted, I mean, I've put things on websites for forever, and I'll put in the footer, copyright, whatever year. Is there a certain time limit to copyright? I guess that's my first question. And the second question is just to clarify that you said if you put something in a specific medium, like print or film, that's copyrightable. But so does that also apply to the internet, or are there special things about the internet?
I don't believe that the internet is different. I think that if they call it a tangible medium, but I really think it's just kind of more of a fixed medium. You know what I mean? And I think publishing something on the internet, or, putting something onto a website is just as valid as writing it on paper or taking a photograph or anything like that. As long as it's something that's original and creative to you, and you've published it in that way. And I hesitate to say publish, because the law always says you don't have to publish, but if it's fixed and written down in that way, then that counts.
I was trying to put this in the chat, but the way this Zoom is set up, it's hard to do it. So you guys could have this. So I'll send it to Jamie, and maybe Jamie can send this out to the group, just so you have a sample of what it looks like. And it tells you when it was first used and some other stuff. So I can send these two out just so you have a sample of what it looks like. And honestly, I think that with a lot of the stuff we've done, with the terms you've used, the slogans you've come up, I think as Attorney Vinci said, I think this is probably something most of us want to give some thought to with the terms that we've developed with our products.
Yeah, if there's anything that you're using in association with your products or your services, it's something that is possibly trademarkable.
Sharon, please, Dr. Sharon. Sharon.
Still sounds weird to be called doctor, but anyway, my internet's going in and out, so I'm going to try real quick. If you have like a logo and a slogan and a graph or a chart, and should you like copyright or patent each one of those things, or should you, like as a group, do them together?
So I think it depends on what exactly you're using. So a lot of times I will have clients in the trademark space who trademark a name, and you can trademark a name without claiming it looking any particular way. It's just the words. And that is actually what Nat just showed on the screen. That was standard character trademark for the words. And then you can, if you use the word, I think in connection with a particular design, more or less, you can trademark them both together and in a logo, essentially. Like let's see, I'm trying to see if I have something on my desk right now that would be, so that's not a very good one, the Neosporin in front of me, but that's like you could trademark the two things together if that's how you're using it in commerce. And a chart, I think, is, or if it's something that you're using and publishing, whether it's internally or on the internet, that is more of, I think, a creative expression that you might consider copyright for. Is that helpful? Joanne, did you have a question?
Yes. I was talking, you mentioned in terms of software. And the coding and so on. If you use a software designer for your app, how do you approach that?
Okay. So that's actually a really interesting area, and it's called work for hire. So if you create something either in the context of your employment, or if it's like I wrote this word down because I wanted to remember, or if it was specially commissioned. So if you used a designer, you can, when you put into the agreement, whatever the scope of your agreement is with that person, and pay attention to the agreement and how you're negotiating it, because it's possible for sure that if you're an employer or if you commission somebody to create something for you that is creative and unique and copyrightable, that goes to you. The copyright goes to you as the person who commissioned it. But it depends kind of on the situation and the context and what's in the contract between the two of you, whether it's a work for hire and and it's yours as the person who commissioned the work, or if it belongs to the person who created it under the scope of that commission. But the default is usually that it goes to you as the person who commissioned it. And
that would include trademark, not just copyright.
That would just include copyright. So trademark is, I mean, if you are using something, like if someone made a logo for your company or for a service that you're putting together, you're going to be the person who's using it. Your company is who's using it, and so that's what matters for trademark. It matters who is using it and how you're using it in commerce, pretty much. So that would then, with respect to that, if I am a graphic designer and I make a logo for you, I pass it off to you, and you're going to be the person who's using it. So that common law trademark right is yours in theory, and if anyone were to register, you would register it. Because I'm the graphic designer, I'm not using it in the way that it's intended to be used. You know what I mean?
Stacy, please.
Brianna, thank you very much. I have a question because I work for the government and I'm in a situation with another, something not related to what I develop, but what I'm hearing from our general counsel is if you work for the federal government, like you can't trademark anything. I guess the government owns it. And I was like,
In the context of your employment.
yeah. And I was like, well, what the hell? Then people are just going to run rogue with the stuff that we put together.
Well, Dr. Stacy, I think you glossed over what she asked. You didn't. What you developed in USC was not in the context of your employment. Am I correct?
That is correct. But the launch of it and the actual is
No.
my
The product you developed was not an extension of, or was it? I don't want to.
no.
And that's what you're.
I would
And
ask,
I think that's why.
did you do it on federal government time? Were you paid to do it? Did they pay for your schooling? Like there's certain conditions under which I think like if you create something and you're a federal government employee, that counts. But if they didn't pay for your school, if you didn't use government time or resources to generate your materials, then that shouldn't be seen as anything that belongs to the federal government.
They didn't buy your heart, soul, and.
Nope. I'm paying my student loans. Thank you very much.
I think it does. I think like Jamie said, that situation, I think it depends on a whole bunch of things. And I don't know a ton about what happens when you're a federal employee and you invent something, but I would think that whether it's happening within the scope of your employment matters, and I think there's probably other factors, and it, if there was something that you invented, and it might be helpful to ask an attorney to do a little bit more of an in-depth analysis than I'm doing right here on the fly. But
Fair enough.
yeah, I think the answer, and I hate to be like, it's such a lawyer thing to say, that depends.
No, but I get it.
It really does.
Too much gray.
Dr. Mitch. Dr. Mitch, and we're coming close to our time with Attorney Vinci. So Dr. Mitch.
Just a quick question in terms of the work that we've done in the within the program, the graduate program we just completed. To what extent, and this may be the similar question that you may or may not be able to answer, to what extent does the university have a hold on any of that intellectual property?
I think that's a really interesting question. And it's not, I think it depends. Again, that's one that depends. And I think it might also depend on like the university's individual policies. So I think every university is different and unique as an entity. And I haven't had a ton of opportunity to do research on whether, what you invent during your time in a particular program is yours or belongs to the school. But if I have the opportunity to, I'll make sure I circulate it to Nat and Jamie, and because I would like for you guys to be able to have at least, a general understanding of that information.
Okay, thank you.
Any other burning questions before we thank Attorney Vinci for her time? Well, we thank you sincerely for your
Thank
time.
you all. I hope it was interesting and semi-informative.
Will
And
you share that PowerPoint with us? Is that okay?
Sure.
Okay.
Yeah, that's absolutely fine.
If you could share with Jamie, because she actually, or Stacy, because they actually maintain the list of the contact list, but we'd love to have that as soon as you can.
And Brianna, just as a follow-up, if people have questions, I know you're based in Pennsylvania, but people on here are all from different parts of the country. If they have questions, can they reach out to you and either you can assist or guide them to a firm that you work with or something like that?
Absolutely. So yeah, the one wonderful thing about intellectual property is that it's a federal law. So I can practice and assist clients who are from anywhere within the United States or want to do work within the United States, which is very nice. And we have licensed patent attorneys at my firm and all of that. So I'll drop my email in the chat. So everybody has that. And mmwr.com is my firm website if you guys wanted any other information.
And it'll be on the PowerPoint itself as well, right?
Yes.
That's-
Yeah, that'll all be on there. So I would love to hear follow-up if anyone has anything or thinks of something anytime, whether it's this week or like months from now. I'd love to hear from any of you.
Again, thank you so very much.
Thank you so much for having me. It was really nice to meet all of you.
Thanks.